Imagine you are buying shares of a listed company. You slowly increase your holding. At first, nobody is worried. Then your shareholding crosses an important threshold. Suddenly, the question changes. Are you still just an investor? Or have you become an acquirer under SEBI SAST? And what if you are not buying the shares alone? What if another person is acting together with you? What if you acquire control without acquiring a majority of shares? And what if the shares are acquired indirectly through another company? This is where the SEBI SAST regulations become critical. Because in a takeover situation, 1% can change everything. One transaction can trigger an open offer, and one wrong interpretation of control can create a major compliance problem. So today, we are starting a completely new master series, SEBI SAST Regulations 2011. And in Lecture 1, we are not jumping directly into the open offer calculation. We are going to build the foundation first. Because before you understand Regulation 3, Regulation 4, Regulation 10, or Regulation 18, you must understand one thing. Who is an acquirer? What is acquisition? What is control? Who is a person acting in concert? What is a target company? What is an offer period? And what exactly do these regulations apply to? By the end of today's lecture, you will understand the foundation on which the entire SAST framework is built. Welcome to Corporate and Securities Law Compass, navigating the law with clarity. This is the SEBI SAST Master Series. Lecture 1. Today you will learn. Today we are starting from Regulation 1, short title, Commencement and Applicability. Then we move into Regulation 2, Definitions. And this is where today's real learning begins. We will understand acquirer, acquisition, act, board, control, convertible security, delisting regulations, disinvestment, government company, enterprise value, financial year, frequently traded shares, fugitive economic offender, identified date, indirect acquisition, insider trading regulations, listing obligations, manager to the offer, maximum permissible non-public shareholding, offer period, persons acting in concert, promoter, public announcement, recognized stock exchange, specified, state-level financial institution, stock exchange, target company, tendering period, total paid-up share capital, and willful defaulter. But do not worry, I will not make this a dictionary lecture. We will understand the definitions through a story. Because once you understand the story, the definitions become much easier to remember. Imagine a listed company called ABC Limited. ABC Limited is already listed on a recognized stock exchange. The company has promoters, it has public shareholders, and it has a large number of investors. Now imagine Mr. X. Mr. X wants to acquire a significant stake in ABC Limited. He starts buying shares. But before we ask how many shares Mr. X can acquire, we need to ask a more basic question. Who is Mr. X under SAST? The answer begins with the definition of acquirer. Definition of acquirer. Under the regulation, an acquirer means any person who directly or indirectly acquires or agrees to acquire shares or voting rights in the target company. It also includes a person who acquires or agrees to acquire control over the target company. Stop here. This definition has two important roots: shares or voting rights and control. So you can enter the SAST framework not only by acquiring shares, control itself can become important. That is why the word control is one of the most important concepts in this entire master series. Practical example. Suppose Mr. X acquires shares of ABC Limited. that is, an acquisition of shares. But suppose Mr. X enters into an arrangement that gives him control over the management or policy decisions of ABC Limited. Even if the shareholding percentage does not tell the whole story, the concept of control becomes important. So remember, SAST is not only about percentage, it is also about control. Definition of acquisition. Now we come to acquisition. Acquisition means directly or indirectly acquiring or agreeing to acquire shares, voting rights, or control over the target company. This is important because the regulations cover both direct and indirect acquisition. Imagine Mr. X buys shares of ABC Limited directly, that is, direct acquisition. Now imagine Mr. X acquires a company that already controls ABC Limited. That can raise the question of indirect acquisition. So whenever you analyze a transaction, ask three questions. What is being acquired? Shares, voting rights, or control? And is the acquisition direct or indirect? Definition of act. Now we come to the word act. The definition refers to the Securities and Exchange Board of India Act 1992. Why is this important? Because throughout the SAST regulations, the word act may appear repeatedly. Instead of writing the full name every time, the regulations define it. This is a simple definition, but it is important for reading the regulation correctly. Definition of board. Board means the Securities and Exchange Board of India, established under the Securities and Exchange Board of India Act 1992. So when the regulation says board, remember, it means SEBI. This matters because the SAST framework is administered by SEBI. Definition of control. Now we reach one of the most important definitions in the entire SAST framework: control. And this is where many students make a mistake. Control is not simply the same thing as majority shareholding. The definition includes the right to appoint majority of the directors. It also includes the ability to control the management or policy decisions of the target company. That control can be exercised directly or indirectly, and it can be exercised through shareholding, management rights, shareholders' agreements, voting agreements, or in any other manner. This is extremely important because a person may have a significant influence over a company even when the person does not hold more than 50% of the shares. Story example. Suppose ABC Limited has 10 directors. Mr. X has the contractual right to appoint the majority of those directors. Does Mr. X have control? You cannot answer this question merely by looking at his percentage shareholding. You must examine the rights attached to the arrangement. That is why control analysis is a legal analysis, not merely a mathematical calculation. The big curiosity. Now think about this. Suppose Mr. X owns only 20% of ABC Limited. But because of an agreement, he has the right to appoint the majority of directors. Can Mr. X have control? This is the question I want you to answer in the comments. Yes or no. Do not look only at 20%. Think about the definition of control. Convertible security. Now imagine Mr. X acquires a security today, but that security can later be converted into equity shares. The definition of convertible security becomes relevant. The regulation recognizes a security which would entitle the holder to receive equity shares at a later date. This is important because takeover analysis can involve instruments that may convert into equity. So when you analyze a transaction, do not look only at existing equity shares. Look at the nature of the instrument and the rights attached to it. Financial year. The regulation also defines financial year. The definition refers to the period of 12 months commencing on the first day of April and ending on the 31st day of March. Why does this matter? Because many regulatory calculations depend on the financial year. So when a provision refers to a financial year, you should know exactly what period is being considered. Frequently traded shares. Now we come to another important concept: frequently traded shares. The regulation provides a specific framework for determining whether shares are frequently traded. The concept is important because several SAST provisions depend on whether the shares of a target company are frequently traded or infrequently traded. So, this is not just a definition to memorize, it can affect the application of other provisions. And that is why, later in this master series, when we discuss open offer pricing and related calculations, this definition will become very important. Identified date. Now imagine an open offer process is taking place. There needs to be a specific date for determining the shareholders who are entitled to receive the letter of offer. That is where the concept of identified date becomes important. The identified date is connected with determining the names of shareholders to whom the letter of offer is sent. So remember, identified date is not just another date in the takeover timetable. It has a specific regulatory purpose. Indirect acquisition. Now let's return to our ABC Limited story. Mr. X does not directly buy ABC Limited. Instead, Mr. X acquires another company. That other company holds shares or control in ABC Limited. What happens now? This is where indirect acquisition becomes important. The SAST framework recognizes that an acquisition can occur through another entity. So the analysis cannot stop at the immediate transaction. You may have to look through the structure. Who acquired whom? What does the acquired company own? Does it hold shares or control in the target company? This is the type of question we will explore in detail in later lectures. Offer period. Now imagine a public offer is announced. There is a period beginning from the date of the public announcement and ending on the date when payment of consideration is completed to shareholders who have accepted the offer. That period is relevant for understanding the offer period. Again, remember, SAST is highly process driven. Dates matter, deadlines matter, and the meaning of each date matters. Persons acting in concert. Now we reach another major concept: persons acting in concert. Imagine Mr. X wants to acquire ABC Limited. Mr. X is not acting alone. His company is involved. A family member is involved. Another entity is involved. And all of them share the same objective of acquiring shares or control. Should SEBI look at every person separately? Or should their holdings and actions sometimes be considered together? This is where the concept of persons acting in concert becomes critical. Basic concept. Persons acting in concert means persons who have a common objective or purpose of acquisition of shares or voting rights in or exercising control over a target company. The regulation looks at an agreement or understanding, formal or informal. And the understanding can exist directly or indirectly. This is a very important concept because two persons may not have a formal written agreement, but their conduct and common objective may still become relevant under the regulatory framework. Practical example. Mr. X owns 10% in ABC Limited. Company Y owns another 10%. Mr. X and Company Y are independently making investments. That is one situation. Now suppose Mr. X and Company Y have an understanding that they will jointly acquire shares and exercise control over ABC Limited. Now the analysis changes. The question becomes, are they persons acting in concert? This is why you cannot simply look at individual shareholding. You have to understand the relationship and objective behind the acquisition. Promoter. Now we come to promoter. The definition refers to the meaning assigned under the SEBI framework. So when you see promoter in the SAST regulations, do not casually assume that promoter simply means founder. You must examine the regulatory definition. This becomes important when we later discuss promoter shareholding, acquisitions, and exemptions. Target company. Now, one of the simplest but most important definitions. Target company means a company and includes a body corporate or corporation established under central, state, or provincial legislation, whose shares are listed on a stock exchange. In a takeover transaction, this is the company whose shares, voting rights, or control are being acquired. So in our story, ABC Limited is the target company. Public announcement. Now imagine the acquisition has reached a stage where an open offer obligation is triggered. The market cannot remain unaware. The SAST framework uses the concept of public announcement. This becomes a critical event in the takeover process. Later in this series, we will study who makes the public announcement, when it is made, what it contains, and what happens after it. Manager to the offer. Another important definition is manager to the offer. The manager to the offer means a merchant banker referred to in the regulation. This role becomes extremely important in the open offer process. Later, when we enter the detailed open offer procedure, you will see why the manager to the offer is central to the process. Maximum permissible non-public shareholding. Now remember another important phrase. Maximum permissible non-public shareholding. This relates to the maximum percentage of shares that can be held by non-public shareholders in the target company. Why does this matter? Because takeover transactions cannot be analyzed without understanding the public and non-public shareholding structure. It becomes particularly relevant when determining the shareholding position after an acquisition. Recognized stock exchange. The regulation also uses the concept of recognized stock exchange. This refers to a recognized stock exchange within the meaning of the Securities Contracts Regulation framework. In simple terms, when the regulation refers to a recognized stock exchange, you should connect the term with the applicable securities law framework governing recognized stock exchanges. State-level financial institution. The regulation defines state-level financial institution as a financial corporation established under the relevant state-level legislation and recognized under the applicable provision. This definition may look technical, but remember the broader lesson. When a regulation defines a term, do not assume that the ordinary English meaning is enough. The regulatory definition controls. Stock exchange. Stock exchange is defined with reference to the Securities Contracts Regulation framework. Again, the important lesson is cross-reference. SAST does not operate in isolation. It uses concepts from other securities laws and regulations. That is why a company secretary studying SAST should understand the connected regulatory framework. Tendering period. Now imagine the open offer has actually opened. Shareholders are given a period during which they can tender their shares. This is the tendering period. The definition links it to the period during which shareholders may tender their shares in acceptance of the open offer. Later, when we study the complete takeover timetable, this date will become extremely important. Total paid up share capital. Now we come to another calculation concept. Total paid up share capital. The definition deals with the total paid up share capital of the target company. This matters because acquisition thresholds and voting rights calculations can depend on the relevant share capital. So, whenever you calculate a percentage under SAST, do not blindly use the number you see on a balance sheet. Understand what the regulation says should be included in the relevant calculation. Willful defaulter. The regulation also defines willful defaulter with reference to the applicable banking framework. Again, this is a reminder that SAST contains cross-references to other regulatory frameworks. A professional reading the regulation must know when to follow the definition provided inside SAST and when the regulation refers you to another law or framework. The master story. Now let's put all these definitions together. Mr. X wants to acquire ABC Limited. ABC Limited is the target company. Mr. X is the potential acquirer. He wants to acquire shares and voting rights, but another company is also participating. So we examine whether the parties are persons acting in concert. Mr. X may also acquire control. So we analyze the definition of control. The acquisition may be direct, or it may happen indirectly. If an open offer obligation is triggered, the public announcement becomes relevant. The manager to the offer becomes involved. The offer period begins. The identified date becomes relevant. Shareholders receive the letter of offer. The tendering period opens, and shareholders decide whether to tender their shares. Do you see what just happened? We started with definitions, but the definitions created the entire takeover story. Your first master question. Now let me test you. Mr. X holds 20% of ABC Limited. He has an agreement giving him the right to appoint the majority of directors. Does your analysis stop at 20%? Or must you examine control? Comment your answer. The correct approach is to examine control. Because the SAST definition of control goes beyond simple percentage ownership. Second question. Mr. X and Company Y each hold shares in ABC Limited. They have an understanding to jointly acquire additional shares and exercise control over ABC Limited. Should you examine their holdings separately? Or should you examine whether they are persons acting in concert? The correct approach is to examine the persons acting in concert concept, because the common objective and understanding can be relevant. Third question. Now imagine Mr. X acquires a company that itself holds shares in ABC Limited. Is that automatically a simple direct acquisition of ABC Limited? No. You must examine whether the transaction constitutes an indirect acquisition under the SAST framework. This is exactly why structure matters in takeover transactions. Secretarial and compliance checklist. Now imagine you are reviewing a proposed acquisition. Your first checklist should be simple. Identify the target company, identify the acquirer, identify the shares and voting rights proposed to be acquired, identify whether control is being acquired, check whether the acquisition is direct or indirect, identify persons acting in concert, examine their common objective and understanding, check the existing shareholding, check the proposed shareholding, check the relevant share capital, check whether the shares are frequently traded, identify the relevant dates, and then determine which substantive SAST provisions become applicable. Rapid recap. Today we started a completely new master series, SEBI SAST Regulations 2011. Regulation 1 gives us the short title, Commencement and Applicability. Regulation 2 gives us the definitions, and some definitions are especially important. Acquirer, acquisition, control, persons acting in concert, target company, public announcement, offer period, identified date, tendering period, manager to the offer, and indirect acquisition. The most important lesson from today's lecture is simple. Do not start a takeover analysis by calculating percentages. Start by identifying the parties. Understand the transaction. Understand the rights. Understand the control. Understand the relationship between the parties. And then apply the relevant SAST provision. But this was only the foundation. Because now you know who the acquirer is, you know what acquisition means, you understand control, and you know why persons acting in concert can completely change the calculation. But here is the real question. When does an acquisition actually trigger a mandatory open offer? Is it simply when you cross a particular percentage? What happens when you are already holding shares? What happens when you acquire additional shares? And what happens when control changes? That is where the real SAST calculation begins. And that is exactly what we will unlock in the next lecture. SEBI SAST Master Series, Lecture 2, Corporate and Securities Law Compass, Navigating the Law with Clarity. If you want to understand SEBI SAST from the foundation to the practical open offer process, subscribe to Corporate and Securities Law Compass. Do not just memorize the regulations. Understand the transaction. Understand the threshold. Understand the trigger. And understand the compliance consequence. I will see you in Lecture 2. Welcome to Corporate and Securities Law Compass. I am a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a Company Secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. They do not represent the views of my employer, any organization with which I am associated, any client, or the Institute of Company Secretaries of India, ICSI. The content is based on publicly available laws, rules, regulations, judicial pronouncements, and regulatory materials, or on hypothetical examples prepared for educational purposes. No confidential, proprietary, or unpublished information is used or disclosed. This channel does not provide legal, tax, financial, accounting, investment, or other professional advice. Viewers should consult qualified professionals before making any legal, business, or investment decisions. While every reasonable effort has been made to ensure accuracy, laws and regulations are subject to change. Accordingly, neither I nor this channel accepts any liability for any loss or consequences arising from reliance on the information presented. All trademarks, company names, and logos belong to their respective owners and are used only for educational, commentary, and informational purposes. Copyright, Corporate and Securities Law Compass, Navigating Law with Clarity. All rights reserved.